All right, good afternoon. This is Attorney Vincent Davis. This is CPS Office Hours, where you ask the questions and I give you the answer. If you want to be a guest on the show, please email Grace, our producer, grace@vincentwdavis.com, or call Grace at 888-888-6582. Grace, who do we have as a guest this evening? Miss G, how are you? Miss G is on mute, so I can't hear
Hi.
her. Miss G, you had a question for me on office hours today?
Yeah, I have several questions actually.
Let's get to them.
Okay, so I'm gonna send you the name of the county I'm talking about because you're on your phone, you cannot see it, but it's a county I'm not gonna mention the name of. It's in California. So now the social workers are ordering air tags from Amazon, sending them to the home of the caregiver, telling the caregiver to put an air tag on each of the children and an air tag on her. And she wants to monitor where the visitations are being held. She wants to monitor every step of the children and not tell the mother. That social worker ordered it from Amazon. That was delivered again to that caretaker's home, and that caretaker is a friend of the mother.
So what's the question?
The question is, have you heard anything like this? And can they, I guess this is new to me and new to everyone that I speak with now. Is that something new that the state is doing, the county is doing, that you heard of?
Never heard of that before.
Yeah.
Air tags will only track geographical locations. They won't track what's happening at a visitation, and they won't track what's said during a visitation.
Right.
So it's probably illegal, with respect to privacy, but, they can't get any information other than geographic.
Right. She understands that, but that's what the social worker wanted her to do, the caretaker. So, um, yeah, it's kind of weird. That was one question that I wanted to ask you. The second question is that this matter is out of state, it's in Tennessee. The mother, I mean, the aunt of the child who was now 14 years old, she had custody of him in 2016. But the custody did not come from
Hold on,
CPS
Miss
or
G.
anything.
Miss G,
Uh-huh.
you're telling me a story. Ask me a question.
The
It's
question
office
is, the aunt
hours.
had custody of the teenager in 2016. CPS removed the teen on February 8th, 2024. The question is, the social worker told the aunt that she didn't care about custody and that the mother abandoned the child, and that they removed that kid because the mother abandoned the child by leaving the child with the aunt. So my
So
question is,
usually the questions,
can they
go
do
ahead.
that?
Your question is?
Can they do
Yes.
that? But she didn't
Yes. The
abandon the
answer is
child.
yes. The answer is yes. They can do that. But the mother is left with different remedies, such as going to court, getting the child back, perhaps suing the social worker for civil rights violations. So you asked me, can social workers do that? Yes, they can do anything that you think of. Is it the right question is it legal?
Is it legal? I guess, yeah, you're right. Is it legal for them to do that? Sorry. Yeah.
Probably not, but they do it anyway. I mean, you know, you've been in this particular field for a while, and do social workers do anything that is illegal or violation of civil rights? Yeah, but they do it anyway, right?
Yes, I
What's your next
understand.
question, Miss G?
Um, what would she paid? Okay, so she hired an attorney. The attorney told her that he cannot intervene unless he gets approved first. And is that something? And that attorney is in the same state as her case. So is that something that you heard? Is that something? Is that the? Is that a truthful answer? I mean, question. I mean, answer to his client that he cannot
I
do.
would say I could say probably, but he has, if the case were in California, he would have to make a motion to intervene. So, his approval is conditioned on his action, right?
Okay. Yeah.
It's just not gonna happen with him sitting in the office, right, doing nothing. He's got to make a motion or a petition for approval.
Makes sense. What is the legal age of
All
a
right,
child? Oh, my
next
next question.
question.
What is the legal age of a child to make a choice on who they want to be with when they're in the state custody?
The child can't ever make the decision. What the law in California says is that at the age of 12, the judge has to consider what the child wants. Considering what the child wants is much different from making the decision. You agree?
I agree, but
But
okay.
nothing. Children don't make decisions, the judges do. What the judges have to do is consider when the child turns 12, 13, 14, 15, 16, 17, what the child wants. And obviously, as the child gets older, the judge has to give it more weight in making a decision on where to place the child. Okay?
So in the state
Right.
custody, okay, the child does can't. Okay, got it, got it.
Child can't make a decision ever.
Right, but they can make a decision to have sex change. An operation without their parents' consent. I mean, I guess, I guess it doesn't
That's
make
not, you know what? That's not true. So everything in it that goes on in a child's life in a CPS case is up to the judge. Up to the
Mm,
judge.
okay.
Okay.
My okay. My next question is when the parent is at the TPR stage, termination of parental rights, and they want to hire an attorney. I get questions all day today. What can the attorney do for me if I hire that attorney to stop the adoption?
Well, let's say that you hired me today and the TPR is in 60 days. What I would do for you is I would review the file. I'd come up with a strategy that's generally implemented by these three things. Number one, I'd file a 388 petition to get you more family reunification services, assuming your family reunification services have been terminated. The 388 would also include a request to get you more and more liberalized visitation, not monitored, maybe overnights, that type of thing. The most important thing I would do for you is probably make a motion, if it hasn't already been ordered, for a bonding study. In California, one of the best defenses is to prove that the child has a relationship with you, the mother, that that would be detrimental if your parental rights were terminated. Okay, and the best way to do that, evidentiary wise, is through a bonding study. But you have to actually make a motion and ask for that bonding study. The next
Perfect.
thing I would do is I try to figure out a strategy based upon all the reports and evidence to come up with a defense for the termination of your parental rights.
Okay, great. A couple of people are hearing this message, and I needed them to hear it. Um, when a parent loses twins, one is returned to them, the other one is kept with the state. What can they do to get the other child back? Because they're both twins, same age, same everything, obviously. But one of them they're keeping in their custody, and the other one is they brought the child back home. What if
Okay,
they hire us?
in the
This is
case,
LA. This is LA County.
okay, so that whole scenario you just gave me doesn't make sense. Have heard it happening before? Yes,
Hmm.
several times, and it just doesn't make sense to me, because
Hmm.
the standard is you don't get your children unless you are a substantial risk or danger to the children. Now, if they give you one child back, how could you be a risk or a danger to the other child? See, it doesn't
Right.
make sense. So factually, there must be something going on in the case that you don't know about. For example, one kid is medically fragile and the other kid isn't, or one kid has special needs and the other one doesn't. That's the only logical thing that I can think of. If none of that is occurring in this fact pattern, then it just doesn't make sense that they return one of the twins and not the other. And what that person should do is talk to their attorney about filing a 388, getting back in court, producing evidence to the judge. The other thing, this came up today when I was talking to a client. You as a parent, when you go to court and try to file these motions and stuff, if the judge rules against you, you have to be prepared to take it up on a writ to the appellate court, because sometimes I get the feeling that decisions are made because they know that you aren't going to do anything appellate wise, or you don't have the resources to do anything appellate wise. So, if I make a decision against you as the judge and I know that you're not going to do anything, theoretically, I could do whatever I want, whatever I felt is best, whether I'm following the law or not.
Okay.
Right?
Right.
Okay.
Perfect.
So our system is based upon checks and balances. Remember that from grammar school or high school when you took civics. Everything is checks and balances in our system, and there is a reason for that. The way our government was formed. In the judicial scenarios, in courts, there's checks and balances. The balances and the checks are you being able to take this case to a higher court so that they can review and so that you can challenge what a judge has decided.
Okay.
Remember, in California, decisions are made in the trial court, in the Superior Court of California. If you don't like what the judge does in the Superior Court, you can appeal it to the Court of Appeals. If you don't like what the Court of Appeals does, you can appeal it to or take a writ to the California Supreme Court. And if you don't like what the California Supreme Court does, you can always try to take it by way of writ to the United States Supreme Court. Okay?
Okay.
So there's always checks and balances. Now, whether the parent knows that or takes advantage of that, or even can afford to take advantage of all of those checks and balances, that's a whole nother thing, right? I'm just telling you theoretically what can happen. What people do in the long run is up to them.
Okay.
Do you have another question for me?
Yeah. Is it legal for CPS to allow a sex change on a child who is 9 years old?
No. The question is, can the judge allow it? And the answer is, can the judge allow it? The answer is yes, based upon facts and evidence given to him or her. CPS can't do anything. They can write a report either saying the reason why that it should happen or shouldn't happen, but the ultimate decision for a child having any non-emergency medical treatment is with the judge. And here's the thing, although it sounds ridiculous that this could ever happen, you don't know what the evidence is in the case. All right? That's the danger of making, blanket statements that it should never happen. I don't know very much about sex change operations. All I know that whenever the judge makes a decision, the judge is supposed to be using law and evidence to make that decision. Just because a judge makes a decision that you don't personally like, well, that happens every day, not just in sex change operations. So can the judge order it? Yeah, the judge can order it. Now, here's the thing. If you're the parent, and we just talked about this, if you're the parent and the judge makes that order and you don't like it, what do? You appeal it. You take a writ on it, right? So, but if you don't appeal it, you don't take a writ on it, then there's nothing that you can do. You're not taking advantage of our system's checks and balances when you don't file a writ or file some type of appeal.
Okay, and how many times can you appeal?
Well, I just told you. Once from the Superior Court to the Court of Appeals, from the Court of Appeals to the California Supreme Court, from the California Supreme Court to the United States Supreme Court, and in some instances, you can take your matter over to the federal courthouse and seek some type of writ, because sometimes these are important federal rights, and sometimes, the federal court can or might be able to intervene. So there's a lot of checks and balances you can use. The question becomes, do people take advantage of it? Hey, Ms. G, that's all for right now.
Yep.
We're going to have another session, probably in 2 or 3 hours, another CPS office hours. And I think that we do it at 5 or 5:30, but Grace will set it up, notify everyone on social media. and I will see you guys then.
Okay, it's at 5
Bye-bye.
o'clock, by the way. Okay.
All right.
Uh-oh.